Services, attorneys Colin Hector, Hannah Juris, and Thomas Bellavia. Did I do that correctly, Mr. Bellavia?
That is correct, Your Honor.
All right. Defendant Julia Lyons appears by video. Attorneys Joseph Russell and Rebecca Roker appear on her behalf. For proposed interveners, the Mix-Up Inc. and Liz Sieben, attorney Misha Saitlin, by video, attorney Kevin Leroy by audio. I don't see that anyone's appearing for proposed interveners Pro-Life Wisconsin Education Task Force, Inc., or Pro-Life Wisconsin, Inc., or Dan Miller.
Your Honor?
Yes.
Saitlin, pursuant to my letter to you on Friday, while those proposed interveners are represented by separate counsel, they have authorized for me to speak on their behalf at this hearing.
Okay, I knew that they were relying on your brief. I didn't know that they wouldn't be here for the hearing.
Yes, they have authorized me to speak on their behalf at the hearing.
Excellent, thank you. Is there anyone that I have connected by Zoom? I see Ms. Roker just lost her. I'm going to bring her back in again. She lost connection. Anybody else that I've joined for parties or counsel that I did not note for the record? No one has responded. We are here on the request for a temporary injunction, and just to take care of some of the logistics, I have 2 hours set aside. I'll require that only one lawyer per side is able to argue. Otherwise, it's just too confusing, especially doing this by video. And then I have a question of, first of you, Mr. Johanningmeyer, did you intend to call witnesses or rely on affidavits?
We intend to rely on the affidavits we filed with our motion, Your Honor.
And Mr. Hector, is that true for the defendants Andrea Palm and Wisconsin Department of Health Services?
Yes, we intend to rely on the affidavit filed by Dr. Westergaard.
And Mr. Saitlin, did your side intend to call any witnesses today or rely on affidavits?
We are also relying on our submitted affidavits, Your Honor.
I just want to make that clear. I thought that was true, but I wanted to make sure that I wasn't missing any witnesses. I can tell all counsel that I spent Saturday and Sunday reading all briefs, affidavits, and court documents, in addition to doing my own legal research. The first issue we need to take up is the motions to intervene. There are 2 separate motions, one by Mix-Up Inc. and Liz Sieben, the other for Pro-Life Wisconsin Education Task Force Inc., Pro-Life Wisconsin Inc., and Dan Miller. I'd first start with you, Mr. Johanningmeyer. Is there any objection to those parties intervening today?
Your Honor, we have conferred with our clients who have not given us direction one way or the other on the interveners because of the late Friday filings and our clients' focus on the temporary injunction motion. So we do not take a position on the intervention motion at this time.
And Mr. Hector, what's the position of the defendants Palm and Wisconsin Department of Health Services?
Your Honor, the DOJ does not oppose the motions of the proposed interveners to intervene in this case.
Okay. When I looked at it, there are 4 requirements for intervention under Helgoland versus Wisconsin municipalities. The first, that the movant's motion to intervene is timely, which I find, that the movant's claim of interest is sufficiently related to the subject matter of the action, which it is, that disposition may, as a practical matter, impair or impede the movant's ability to protect that interest, and I find that that's true. I'm not sure that the existing parties do not adequately represent movant's interests. Seems to me plaintiff has filed an extensive brief, but the movements for intervention, their brief essentially recites much of plaintiffs, but I don't see any harm in joining them. And for the case as a whole, they're certainly appropriate. So I grant the motion for intervention by those parties. All right, then. Going to start with arguments by the parties, and I'm going to start with you, Mr. Johanningmeier. You did file over the weekend, I think it was later on Sunday, a letter brief in reply to the state's brief. Let me just find that here. Is there anything you'd like to highlight from that letter brief, which I read this morning? I did not read it late yesterday. I know it came in late yesterday.
Yes, Your Honor, I would, and I can do so in the context of my prepared argument if you'd like, as it primarily relates to the application of the Supreme Court's decision in the earlier Palm case to this order and its comparison to the other. So I can incorporate it in as well.
I just want to tell all of you, I've spent lots of time reading your briefs, so for your argument, if you make it succinct, because I really have spent lots of time going through this. So go ahead.
Thank you, Your Honor. I'll do my very best to keep this succinct and not a mere recitation of the briefing we've already filed. I want to start out by pointing out that it's pretty rare that you can use state Supreme Court precedent involving the very same defendants potentially against them, particularly in such a short time frame. But that's exactly what happens when they ignore the law and the constraints placed on them by the statutes and by the judiciary's earlier interpretation of the same statutes. And I want to be clear that nobody disputes that COVID is a public health crisis and the state has to address it. And the state has been addressing it for months and months, as has the private sector. But the question at issue here is, what powers do the defendants have to address the pandemic? The scope of those powers might have been something of an open question when the pandemic first emerged in March, but those questions were answered in May when the Supreme Court specifically delineated Defendant Palm's and the DHS's powers. It said that Palm is not without power to act in the face of this pandemic, but to exercise those powers, she must follow the law that is applicable to statewide emergencies. And that's what we're here asking this court to reinforce. Because less than 5 months after the Supreme Court put Palm on notice by invalidating all but one provision of Emergency Order 28 and declaring that those actions and restrictions required emergency rulemaking, the Secretary issued Emergency Order number 3, with no credible excuse or distinction except that the COVID-19 pandemic continues. The defendants' disregard of the Supreme Court decision against them is shocking. Frankly, their 31-page opposition is nothing more than a plea for this court to ignore the Supreme Court or somehow reconsider the High Court's decision, which it cannot do. As we noted in our short reply letter, if you compare Emergency Order 28, Emergency Order 3, and the Palm opinion, you cannot reach any conclusion other than that Emergency Order 3's directives amount to a rule under Chapter 227, and that DHS and Palm must engage in emergency rulemaking to impose those kinds of restrictions. Palm and the DHS, for their part, have provided this court with a lengthy narrative, statistics, and public policy discussion, all related to the pandemic. That's a perfectly appropriate set of material and a kind of discussion that would be had in the rulemaking process. And it's context for their actions here, but it doesn't excuse them. This emotional plea to the court to allow Palm to ignore the law can't be allowed. They even try to excuse the unlawful action based on Emergency Order 3's relatively short duration, as if it's okay to violate the law for a little while, harming Wisconsin citizens and small businesses. But frankly, it could go on even longer if Emergency Order 3 is followed by another and another, which are merely the proclamation of one unelected official. That is not the law, and they can't be allowed to do it. Let's talk briefly about the analysis of Palm and the two relative emergency orders. And this is what was in our short reply letter yesterday, Your Honor. First, there can be no question that Emergency Order number 3 is a general order of general application. The defendants don't make an effort to argue in 31 pages otherwise. They bury their acquiescence in a footnote, number 28, in their brief, in which they also complain that the Supreme Court got the earlier decision wrong. To be clear, Emergency Order 3 applies to all of Wisconsin, including all places that are open to the public, including rooms within a business location, store, or facility that allow members of the public to enter. Like Emergency Order 28 in Palm, the class of people, places, and businesses regulated by Emergency Order 3 is described in general terms, and new members can be added to the class. This has been the test for what is a general order of general application for over almost 40 years. What did Emergency Order 28 do? It closed schools, libraries, places of public amusement, salons, and spas. It also imposed capacity limitations for businesses and gatherings, closing restaurants and bars but for takeout and delivery service, limiting religious facilities and groups to gatherings of fewer than 10 people. It also created essential businesses, and then it limited the number of people who could be there. And the Wisconsin Supreme Court invalidated every bit of Emergency Order 28 except for the school closures. And that should not be a surprise. The statute is explicit that they may close schools, and they close schools. That was not an interpretation of the statute. Now the same defendants have issued Emergency Order 3 with capacity restrictions in public gatherings that are indistinguishable in character from what they unlawfully imposed with Order 28. And they did so without emergency rulemaking demanded by the statute in the Supreme Court. It is obvious that in crafting Emergency Order 3, the DHS and Palm had to implement, interpret, and make specific how and in what manner they intended to forbid public gatherings. The statute doesn't provide all of those details, and contrary to their assertion in their opposition brief, this is exactly the filling up of details throughout the entirety of Wisconsin that is the hallmark of rulemaking. And it was done with nothing more than the assertion of power of one unelected official, Palm, again. Defendants incorrectly claim that Section 252.02 sub 3 wasn't at issue in Palm, but both orders, 28 and 3, invoke it as authority, and the Supreme Court still rejected almost every piece of Order 28. If the defendants were right, then the numerous provisions in Order 28 that I just discussed would not have been invalidated by the Supreme Court. Now, it's clear defendants recognize the weakness of the argument, so they moved to complain about rulemaking. Let's revisit what the Supreme Court said to them in May about rulemaking and this very department and this very secretary. Wisconsin's statutory rulemaking procedure exists precisely to ensure that controlling subjective judgment asserted by one unelected official, Palm, is not imposed in Wisconsin. Formal rulemaking would ensure that the agency wouldn't do something like this by issuing an arbitrary order. Instead, proper rulemaking, even emergency rulemaking, gives stakeholders, like the plaintiffs in this case, an opportunity to be heard and to try to prevent arbitrary capacity limits and other impositions on their businesses that are going to choke the life out of them. Public hearings, petitioning officials, all would be available, even on an expedited basis, in the emergency rulemaking process. And it seems that everyone other than DHS and Palm, and perhaps the governor, recognizes that Emergency Order 3 is obviously a rule. The day after the order was issued, the legislature asked the Nonpartisan Legislative Reference Bureau for clarification. The question was simple: is this an order? Is this order a rule following the Supreme Court's decision in Palm? They got their answer the next day. The Nonpartisan Legislative Reference Bureau attorney said yes.
Then the Joint Committee for the Review of Administrative Rules held an executive session, passed a motion, and directed the DHS to promulgate the policy statements and interpretations of Section 252.02 sub 3 as an emergency rule. As of right now, DHS has been silent about whether it's even going to comply with this directive, although it has been asked. The governor said in public comments that he doesn't think they need a rule because they have the order. DHS also claims in its opposition brief that Emergency Order 3 is not a rule because the plain language of the statute, Section 252.02 sub 3, grants it explicit authority to do what it's done in the order. Yet they need page upon page of briefing to try to explain how explicit it is, including how the statute, quote, must be read, or, quote, should be read, how Emergency Order 3 fits well within the statute, and even talking about what a larger group of individuals is, and how the statute can be interpreted to address individuals from different households coming together. These are clearly implementations, interpretations, and or specifications about how to apply the statute. If they are not, then how did the restrictions in the order come to be? How did Palm arrive at specific capacity limits? Whether it's the 25% for locations that have established capacity limits by a local municipality, or the completely arbitrary 10-person limit for places that do not have one? Who decided to exempt certain businesses, entire categories of them, that would also necessarily bring together individuals from different households? Why were those exemptions granted? All of these determinations and the discussions that would normally go into them as part of the rulemaking process are missing, because it wasn't a process and it wasn't rulemaking, it was a proclamation. If all of that is not filling up the details of a basic statutory grant of authority to forbid public gatherings, then what is? The DHS also complains about the timing of rulemaking, suggesting that it's just too limiting. Well, that timing argument is not only incorrect, it's frankly misleading, Your Honor. Defendants claim that administrative rules become the, quote, rules of the road without a built-in expiration. That might be true for regular administrative rules, but it is not for an emergency rule under Section 227.24. They are limited to 150 days. The Supreme Court commented on that factor as well in Palm. There can be extensions, but only up to another 120 days. The emergency rule process is built to deal with this situation. And in fact, Secretary Palm has used the emergency rulemaking process, issuing 3 emergency rules that took effect in the last 2 months. Not once in defendants' opposition do they reference Section 227.24. The only singular reference to emergency rulemaking in their entire brief is in their introduction, when they claim it would not be complete until after Emergency Order 3 expired. Now, that may be true as we sit here today, although it could probably be a close call. There are 20 days left on Emergency Order number 3 if it's allowed to stand. The reality is, an emergency rule is required, and it could be accomplished in as little as 2 or 3 weeks. DHS argues that it wants to act quickly and effectively. Well, what we have in Chapter 252 and the corollary emergency rulemaking procedure in 227.24 is the quick and effective emergency process that the legislature has chosen for our state. Okay? The Supreme Court endorsed it barely 5 months ago. Even in its opinion, the Supreme Court noted that 60 days would be more than enough time to promulgate an emergency rule under Section 227.24. That was over 180 days ago, and we've seen several rules implemented. Chapter 252 is well designed and it can deal with this pandemic, but it has to be followed by the executive branch. Instead of following the rulemaking process and providing Wisconsin citizens and small businesses the protections created by the Administrative Procedure Act, the defendants issued Order number 3, which is just another singular proclamation. Frankly, the defendants really are arguing to ignore the law with a plea that it's just not good enough for them. Well, if this statutory scheme leaves Wisconsin unable to sufficiently combat this pandemic or the next disaster, then the legislature needs to change the statutes. But Wisconsin small businesses, Wisconsin citizens, trade associations like my clients, who represent thousands of them, are entitled to the protection of the law and the safeguards of rulemaking, rather than allowing one unelected official to issue orders like Emergency Order number 3. If even a portion of the effort that has gone into avoiding this injunction would have gone into starting the emergency rulemaking process last week when the legislative joint committee told them to do so, they'd be well on their way by now. And I want to turn briefly, Your Honor, to arguments about status quo and the harm to our clients. The fact is that when the likelihood of success is so overwhelmingly in favor of the movement, like it is here for us, where the unlawful action is obvious, and the authority that we rely on is both recent and directly on point and against the very same defendants, the other factors play a smaller role, but they aren't insignificant, and they're important to emphasize for the court because they're not only important to our clients, but they're important to businesses around the state who are trying to continue to survive the pandemic as well. The status quo before the emergency order was for small businesses like our client, the Flambeau Forest Inn, and other members of our client associations to safely operate with local rules and requirements guiding them in some locations and guidelines from the WEDC and other sources as well. But they were still suffering losses along the way. Numerous businesses have gone under during the pandemic. We don't need to add more to the list in the name of acting quickly and avoiding the law. Look at Flambeau Forest Inn, for example. My client's supper club could safely hold about 60 dining customers before the pandemic. They were able to reduce the seating into the 40s in order to space things out, enhance their cleaning protocols, et cetera. The imposition of Emergency Order 3 would cut their dining capacity by order to 5 or 6 customers at a time. That is a de facto closure. No small business can operate on a margin like that. Look at the status quo in the city of Milwaukee. It's a particularly curious situation. Milwaukee has its own order to move forward and reopen, including detailed procedures for bars and restaurants. There's a 54-point checklist that they need to go through in order to show that they're operating safely and to remain open. And it's not built on arbitrary capacity limits. That's the status quo there. And interestingly enough, the mayor has said they're just going to keep doing it in spite of the order that we're challenging here today. Defendants predictably try to minimize the perceived harm based on the short time frame of the current order, and that is it will expire 20 days from today. Their argument misses the point. During those 20 days, Flambeau, other of plaintiffs' members, other small businesses and individuals will suffer significant business losses, some catastrophic enough that they cannot continue after. Being driven out of business is categorically irreparable harm, particularly when it's at the hand of the state and there is little to no recourse available after the loss. Finally, the Wisconsin Supreme Court has also indicated that unlawful activity by a governmental entity may be enjoined even in the absence of an express showing of irreparable harm. That is exactly what we have here. The state has argued in its opposition that we aren't talking about the competing harms, that is not the test for a temporary injunction under Wisconsin law, and it's clear in this context why it doesn't apply. The government cannot simply claim public interest of millions of citizens and automatically have it outweigh the interest of litigants who are being harmed by unlawful government conduct. Your Honor, the judicial branch should not have had to step in twice in less than 6 months to rein in unlawful orders by the DHS and Secretary Palm. And this is particularly true when the first intervention was by the state's highest court and the message was crystal clear. The imposition of gathering restrictions and capacity restrictions under Section 252 requires emergency rulemaking. And yet here we are asking the court to intervene because in spite of the language of the statutes, the Supreme Court's ruling in May, and the JCRAR's directive last week to engage in rulemaking, the defendants refused to do so. Simply put, the pandemic did not suspend the rule of law, and our clients' rights matter, as do the separation of powers. The pandemic is real and it is horrific, and our clients are fighting through it as best they can. And we understand that the intentions may be good, but the actions still have to be lawful.
Okay, thank you. Mr. Hector, you're going to argue for defendants?
Yes, Your Honor.
Go ahead.
Plaintiff's position is based on the repeated assertion that Emergency Order 3 is foreclosed by the Palm decision. So I want to spend my time unpacking exactly what emergency order does, where it comes from, and how that action fits under Palm's reasoning and fundamental separation of powers principles. Emergency Order 3 was an agency action in response to the catastrophic situation that Wisconsin is now in. There's no dispute that we are facing unprecedented, shocking levels of new cases every day. In this past week, we broke terrifying new records of over 3,800 new cases and 34 reported deaths in a single day. Now, fundamentally for this case, Emergency Order 3 was invoked or issued under the Department of Health Services power to close schools or forbid public gatherings in schools, churches, or other places in order to control outbreaks or epidemics. The law says exactly what the department can do, close schools or forbid public gatherings, and the circumstances under when the agency can exercise that power to protect against outbreaks or epidemics. Emergency Order 3 simply applied that directive to the situation at hand. That is quintessentially an executive function, applying the law. It is not lawmaking. Plaintiffs make a fundamental error by reading Palm as essentially saying that anytime there's a statewide order, if it involves any discretion by the executive, it must go through rulemaking. But that's inconsistent with the plain language of Chapter 227, Palm's reasoning, and fundamental separation of power principles. To start with the plain language of the statute, not all general orders of general applicability are rules. They have to do something more. They have to implement, interpret, or bring specific legislation or make specific legislation enforced or administered by an agency or govern the internal procedures of an agency. All of those things get at something common. They get at the metes and bounds of the department's authority. They govern how the department operates going forward. Now, they want to read implementation as an interpretation as sort of extending to any time the executive makes a decision as to how to apply the law. But that's wrong for two reasons. The first is it takes those terms completely out of context from their surrounding language, in strict contravention of basic rules of statutory construction. Interpretation, implementation, governing internal procedures, and bringing or carrying a law into effect so that it then can be enforced or administered, those all get at the general authority of the agency. But more fundamentally, that interpretation also fails because it runs headlong into basic principles of the separation of powers. We interpret statutes consistent with underlying constitutional principles. And there is perhaps no more fundamental principle than that the legislature makes the law and the executive applies and enforces the law. So when the executive invokes discretion in applying the law, that is an executive function. That conclusion flows directly from the majority's reasoning in the Palm decision. The rulemaking section in Palm starts with the court finding that Safer at Home was a general order of general applicability. But it didn't stop there. It went on to address the reason that the Safer at Home order was a rule. And that focused solely on subsections 4 and 6 of 252.02. Those provisions of law, they empower the department to issue orders or take emergency measures, but critically, they don't specify the kinds of orders or the type of measures that the department can take. For that reason, the Palm majority found that Safer at Home didn't just apply the law, it was also making an antecedent interpretation of what the department's authority is generally under those statutes. And that's set forth in the majority's opinion, but I think it's echoed clearly in the concurrence of Justice Kelly. At pages 18 to 20 of Kelly's opinion, he opines that the reason that Safer at Home was a legislative act was because it involved policy determinations. The Department of Health Services had to make the policy determination that it could confine people to their homes, forbid travel, and bar private gatherings. Indeed, when discussing his view of the non-delegation doctrine on page 22, Justice Kelly points out that if the statute authorized the Secretary of Health to confine people to their homes to control an epidemic, it very well might be solely an executive function. That conclusion or that reading of Palm is required under fundamental separation of powers principles. It is no less offensive to our constitutional structure for the legislature to interject itself in executive application and enforcement of the law than it would be for the executive to make the law in the first instance. The legislature and its council, they can't change that through a letter writing campaign. Those separation of power principles need to be applied. And the only way to apply Palm consistent with them and Chapter 227 consistent with them is to confine rulemaking to lawmaking. That is something that gets at the forward-looking authority of an agency. Now, beyond that, I also want to touch on the equities. And at the outset, I think that plaintiffs' contention that this court cannot weigh competing harms is simply wrong. The lodestar case on this is a United States Supreme Court case of Winters versus NRDC. There, the court was faced with an issue of whether certain sonar training programs used by the Navy should be preliminarily enjoined by environmental advocates. The court found that given the harms to military preparedness and the threat that that had to United States security, the equities weighed strongly against the issuance of preliminary injunctive relief. And they noted specifically that that consideration was completely independent of the merits. So whether or not there was a likelihood of success on the merits, which the lower courts found there were, the equities alone demanded that the court deny preliminary injunctive relief. And that case is consistent with just underlying principles of equity. This court sits in equity when it determines a motion for a temporary injunction. And as such, it's obligated to consider the public interest of the requested relief. It's clear from Wisconsin Supreme Court law that that's exactly the analysis that the court takes when issuing a permanent injunction. And there's no sensible reason why that same analysis wouldn't be applied when granting temporary equitable relief, especially given the fact that that represents an extraordinary form of relief that is not granted lightly. Here, I don't think that there's any question that the equities weigh strongly against the issuance of a temporary injunction. As I noted at the beginning, Wisconsin is frankly in a terrible place when it comes to COVID-19 right now. On average, we have 19 reported deaths a day from COVID-19. It is difficult, if not impossible, to imagine another natural disaster like a fire or flood rampaging across the state, killing almost 20 people a day. And if that were the case, no one would blink an eye at the fire department completely evacuating large areas of the state that are threatened by that kind of natural disaster. I don't mean to minimize the economic harm that this pandemic has caused to small businesses that have been shell-shocked during this pandemic. But the only way to bring Wisconsin's economy back is to get this virus under control. Emergency Order 3 is an effort to do that. And of fundamental importance to this case, it is something that is allowed by the direct language of subsection 3. My opponent claims that the reason that the school closures was exempted from the Safer at Home order, and this is somehow lawmaking, is because this involves discretion. But that makes no sense. Of course, the school closures involve discretion. The directive of DHS is to close schools to protect against outbreaks or epidemics. So in Safer at Home, they had to make the determination of how many schools to close. Would it be statewide or more focused? Is there a determination to differentiate schools given the epidemiological facts on the ground? And how long do those school closures last? Here, the Department of Health Services was forbidding public gatherings, and they were doing so based on the facts on the ground. because that is the application of the law and it is a core executive function. Plaintiff's claim and their motion for a temporary injunction must fail. Thank you, Your Honor.
All right. And then, Mr. Saitlin, did you wish to give any argument in addition to your brief?
Yeah, I'll be brief, Your Honor. I want to make a couple of brief points. My friend for the Tavern League already explained why Paul makes clear that a statewide order of business closure and capacity limits is clearly something that needs to go through emergency rulemaking. So I'm just going to make 3 brief points here to supplement that. First, our state's highest court told Secretary-Designee Palm what she needed to do if she wanted to impose business closures and capacity limits. She needed to go through the emergency rulemaking process. Inexplicably, she never went through that process, even though it's been many months since Palm has issued. She could have, for example, in June, July, August, issued an emergency rule that allowed her to have capacity limits if certain COVID-19 thresholds were triggered. Assuming that rule issued by this, in the Wisconsin Supreme Court's words, unelected cabinet secretary was approved by the democratically accountable members of the JCRAR, it would have had legal effect. Instead, what Secretary-Designee Palm has tried to do is go around the legislature, which is elected by the people, and go around the state Supreme Court, which is elected by the people as the final arbiter on Wisconsin law, by issuing a rule using the very same unlawful statewide capacity restrictions by administrative fiat that was struck down in May. Second, in terms of the consequences argument that Secretary-Designee Palm made in her brief, she said, well, it would be impossible for us to respond to an Ebola outbreak or this outbreak. This is the exact same argument that was made by Secretary-Designee Palm in the Palm case. And the reason that argument didn't fly then, it doesn't fly now, is because the governor, who is elected by the people, can issue a 60-day emergency declaration. As soon as a COVID-19 outbreak happens for the state, as happened back in the spring, or an Ebola outbreak of the kind that my friends on the other side have articulated. That 60-day emergency declaration is well more than enough time to go through the emergency rulemaking process. Now, Your Honor may be wondering, well, we have an emergency declaration currently from the governor that has a statewide mask mandate. Why didn't the governor just include these capacity limits in there? Well, the answer is sad and deeply cynical. If the governor had included these destructive capacity limitations within his mask mandate emergency order, he well knew the legislature would have come in and voted down his emergency declaration through a joint resolution. The entire purpose of the gambit here, as it was when Secretary Palm did the exact same thing in the spring, was to avoid the legislature's override authority, avoid the authority of the elected branch speaking for the people. In fact, when the mask mandate was challenged recently in St. Croix County, one of the reasons that Judge Waterman gave in not striking down the mask mandate, he said, well, look, the legislature can come in and vote it down. And that was one of the reasons that AG Hector articulated in his oral argument in front of Judge Waterman. Now, what has happened here is they've used the same procedure that was invalidated in Palm to try to avoid the legislature. Because if they had issued an emergency rule, as Palm requires, the JCRAR would have been able to review it. And if Governor Evers had made this as part of his emergency declaration, then the legislature could have come in and by joint resolution voted it down. Now, my third brief point, at the end of their brief, they say, well, Your Honor, even if you give this temporary injunction, you should stay it pending appeal. And there's a couple of reasons why that's just, I think, a non-starter. First, they didn't even attempt to brief the factors for a stay pending appeal, so I think the issue is waived there. But in any event, they are actively flouting a recent decision from the Wisconsin Supreme Courts. Lower courts in the state have a responsibility to ensure that Wisconsin Supreme Court decisions are followed, not flouted. And it cannot be the case that every time the state Supreme Court issues a decision, private parties, government parties can go around flouting them until the Wisconsin Supreme Court has to enforce its own order. Further, a stay here would effectively deny us and the Tavern League relief because, of course, the order expires on November 6th, and by the time an appeal completes, it's going to be far past November 6th. Given that the legality of the order is so plainly lacking, a stay is just inappropriate. Indeed, I would respectfully submit that given how plainly illegal what is happening here is, and given how clear that what is happening here is Secretary Palm just wants to take this issue up to the state Supreme Court to see if they can get the state Supreme Court to overturn Palm, it may be appropriate to just simply enter judgment in plaintiff's favor and allow the defendants to appeal to the state Supreme Court to overturn Palm. Thank you, Your Honor.
You're welcome. Mr. Russell, did you want to say anything on behalf of defendant Julia Lyons?
Thank you, Your Honor. I think the arguments reflect the fact that this dispute is more about Wisconsin Statute 252.02, powers and duties of the department, as opposed to 252.03, duties of local health officers. I would just like to note for the record that Julia Lyons has not been served the complaint. She doesn't have enforcement powers over, I believe, at least one of the interveners. She has not tried to enforce the emergency order, and I don't think there are any allegations in either of the complaints submitted to the court regarding her activities. So I do not think, other than being named in the caption, that she has done anything that the plaintiffs or the interveners dispute. But I would like the plaintiffs or interveners to clarify if I'm mistaken in some way.
Mr. Johanningmeyer, is it true that Ms. Lyons has not been served?
Your Honor, I have not heard since Friday afternoon. We had been attempting to serve her every day last week, and the process server was told at her office that she's very busy and rarely there. And so we directed them to serve office staff in her stead, and I do not know and have not seen an affidavit yet of service. So I don't have an answer for certain. But I can speak to why she was included in spite of not having any specific conduct alleged in the facts of our complaint, for example. And it is quite simple. I mean, the statutes direct local health officers to enforce communicable disease and orders of the type that DHS has promulgated here. And because we are filing in Sawyer County, we wanted to make perfectly clear that if we were able to obtain a TRO ex parte, that there would be no local enforcement by a local health officer in the meantime. Belt and suspenders, if you will, Your Honor. But that is the reason for her inclusion, because she's part of the enforcement scheme for orders or rules of this type. And
Okay.
if I may, Your Honor, I don't know if I'm allowed a short retort to the state's responsive argument.
I have time left, yes.
All right, thank you. Your Honor, much of my argument focused on the comparison of the two emergency orders in the application of Palm, and specifically the fact that all but one provision of Emergency Order 28 was invalidated by the Supreme Court. And I posed the question, and it was not a rhetorical one, of if it did not involve Section 252.03 and they could do all of these things under Section 252.02 sub 3 without rulemaking, why were all of those provisions invalidated as unlawful? Again, it was not a rhetorical question, and there was absolutely no answer to it from Assistant Attorney General Hector in his argument. And that is because they can't explain it. You can read, and I know Your Honor has done the research and we've reviewed the case, there is reference to Section 252.02 sub 3 in the Palm majority opinion. It is invoked by the order at issue there. There wasn't the deep level of analysis that we have here, because in this case, it's the only subsection they're now relying on, having given up on the other two. And Mr. Assistant Attorney General Hector also brought up, the severity of the pandemic. And I want to point out, without minimizing it, that is the context for Palm's action here. And in the Supreme Court's Palm decision, it said the context is not what drives the question of whether it's rulemaking, but rather the people being regulated. This is a general order of general application. They aren't even arguing about that anymore. Okay, but what they talk about though is it a policy determination? Well, obviously it is. The statute only has 3 words on which they can rely for what they're trying to do here today. And that is forbid public gatherings. There is nothing more explicit than that in the subsection. The details are what matters. Those are policy determinations. We've got in emergency order number 3, 6 pages of detail and prescriptions on activity and definitions. Those are the kind of policy determinations that are the hallmark of rulemaking when the statute doesn't lay it all out explicitly. There is no question this order picks winners and losers. They've given up on labeling things essential and started labeling them as exempt. Okay. One secretary in one department made all of those determinations. No input from the legislature, no input from its Joint Committee for the Review of Administrative Rules, no input from any stakeholder in the state who would be affected by the terms of this order. That is why we have rulemaking to protect businesses, individuals from the acts of one unelected official. Thank you, Your Honor.
I do have a couple of questions for counsel. Let me just find my research here. Mr. Johanningmeyer, my question has to do with preserving the status quo. When I read through the affidavits of your clients, I didn't see anywhere that they said that they have complied with the order and therefore lost business, only that it is anticipated they would lose business if they were to follow the order. Am I accurately reading those affidavits?
Well, Your Honor, the one affidavit from Mr. Madlin from the Tavern League isn't actually the operator of a business, so he wouldn't make a representation like that about the general membership of the association. So you're correct. And as I look at Ms. Slack's affidavit, I don't see where she says we are complying and it is having this effect. It is more of a what effect the order would have. And then, of course, there was the immediate entry of the TRO, at which point she's not obligated to comply. So I apologize if we injected any confusion through the affidavit.
Well, I don't think there's confusion. My question is, if they're not complying, how is the status quo changed if I issue an injunction today?
Well, Your Honor, the status quo doesn't refer to day 1 of emergency order number 3's propagation. It refers to the status quo before the order was issued and took effect. The status quo before the order was issued and took effect was that they were operating with a reduced dining room capacity of 48-ish seats available instead of 60 by spacing the tables, chairs, and whatnot around so that they could achieve social distancing and have more sanitary processes, et cetera. That is the status quo that we're trying to preserve The very brief interim status quo isn't what's at issue here, because the status quo isn't the state of affairs with the order in effect. That's the order we're challenging.
Well, I get that, but how has it changed? Because there's nothing in the affidavit that say that their activities have changed since the issuance of the order number 3. Only that if it were to be enforced, they would be impacted. So tell me what has changed since the day before the order was issued and last week before this temporary restraining order was issued. How has anything changed for your client?
Well, I believe they were operating in a way where they would only have a maximum of 10 people if they were including their staff in a room. But you're right, Your Honor, it doesn't say that in the affidavit. And in the meantime, they were also at risk of an enforcement, a civil forfeiture of $500. So I guess that would have been the structure for those couple days. But I just want to be clear that that's not the status quo we're looking to preserve. We're looking at the status quo before the issuance of an unlawful order. That's what the injunction would preserve.
Oh, and I get that. That's why I was asking, because when I read the affidavit, I don't see anything to say that they've changed what they have done since this order has been issued, only that if someone enforces it, they're not even claiming anyone's trying to enforce it. This is all theoretical.
Well, it is, Your Honor, although we came to court as quickly as we could before there was any enforcement activity, as far as we know, on their premises. They were still under the threat of enforcement and civil forfeitures of up to $500 per violation. So, I mean, that threat was a risk to them. If I'm not understanding the issue here, I apologize, but I'm just trying to make the point that the order took effect. They took action as quick as they could. We're trying to preserve the pre-order status. And in the interim, there was a risk of enforcement against them. And whether they were at 10 or over, we don't have an enforcement action to deal with that.
Well, I think it's an important point, because when I read all the affidavits, I don't see how anyone has been harmed by the order, at least by these plaintiffs, because no one has told me they've changed their behavior. They're saying if the order is enforced, and nor does anyone say I've been contacted by a local health officer, some state health officer, and threatened with enforcement if I don't comply. No one's told me that they've complied with the order and harmed. They're just saying that I would be harmed if I were to comply with this order.
But Your Honor, the threat of enforcement is in the order itself. Paragraph.
Oh, I agree, there's a threat. Right.
Okay, who has to make the threat then, if not the Department of Health Secretary issuing the unlawful order? It says enforcement. This order is enforceable by civil forfeiture, citing the statute and also, ironically, legislature versus Palm, the Supreme Court decision.
Okay.
I mean, there's no question there was a threat of enforcement against them. A local health officer like Ms. Lyons could have shown up. It's included in the order.
Your Honor, may
Mr. Saitlin, I think you wanted to respond.
Yes, Your Honor. If Your Honor looks at paragraphs 20 and 21 of Ms. Sebian's affidavit, she clearly explains that as soon as Emergency Order 3 was issued, they suffered a 50% reduction in sales. And that occurred because when customers heard about the order, and because where the mix-up bar is located, it's a driving bar. It's not like, downtown Madison where most people walk to it. Folks have to know that they're going to be let in. They don't want to drive all the way to the bar and then not be able to come in. So as a result, just in that short window between the issuance of Emergency Order 3 and the obtaining of the TRO by the Tavern League, the mix-up suffered a 50% reduction in sales. And I think we had a very small window where this order was operating, and just my client, saw a 50% drop in sales from the natural incentives that the order creates. And, the order had the effect that it was intended to have, because it sent the signal to the people that the capacity limits are lower. They didn't come to the mix-up, so there was no reason to enforce capacity limits because the people had been deterred by the very order. So the evidence that Your Honor is looking for, I think, is very clearly there in paragraphs 20 and 21. And given the short window in which the order was operative, I think that's pretty good evidence.
But how do I know it's not the general publicity that the COVID-19 pandemic is more rampant in the state? Many people don't pay attention to the law. In fact, most people don't. We lawyers and judges do. But how do I know it's not just general news reports or just word of mouth that I shouldn't go anywhere because I don't want to catch COVID? How do I know that her loss of business has anything to do with the issuance of the order by the department?
Well, two answers to that, Your Honor. First, it is the only evidence before Your Honor. We are here on a temporary injunction posture. It is the only evidence of this. She swore to it on penalty of perjury, and she said that she believed that the emergency order was what caused the reduction. We haven't seen any evidence on the other side contradicting that at all. So I think for the purpose of this preliminary, that's the whole point of a temporary injunction, is it's preliminary. And second, I think it's fair to assume that an order issued by the state's highest health officer has its intended effect. There is publicity and there's not publicity on, but they issued an order that the purpose and design was to have less people go to bars and restaurants. Immediately thereafter, the undisputed evidence is that the mix-up had a 50% reduction in sales. That is, while it's not impossible that it could have been press reports, that is by far the most natural inference that can be drawn from this preliminary posture.
Well, I would say, though, a better inference would be as if she put something out on a sign or in the door saying only X number of people, and then they don't show up. There's no indication she's complied with the order either. Didn't say that she's limited it. Part of we're dealing with legal here, and I'm going to make some comments about the politics or feelings of people. But for a temporary restraining order, we have to show that it's somehow impacted or necessary to preserve the status quo. But her affidavit doesn't say I limited my seating here. Doesn't say she's complied with it at all. So what happens in the general world, where people may just decide not to go out to eat, may not decide to go to bars because of the pandemic, that's going to happen no matter what happens in the law.
Well, Your Honor, even beyond that, you do have evidence from the affidavit of Pro-Life Wisconsin that they are attempting to plan events in the future, and that the order makes it impossible for them to plan those events in the future. Clearly, Mr. Miller does not own an establishment, but I think it's fair for him to assume that the establishments where he would want to plan a fundraiser would comply with the law. So even if Your Honor did not think that Ms. Sebien's and the Tavern League's affidavits were sufficient, and I think they plainly are, there are other plaintiffs before this court that want to conduct fundraising activities at bars, and certainly I think Your Honor should assume that if Your Honor does not issue this order, that places are going to comply. Including the places where Pro-Life Wisconsin would want to hold its fundraisers, and I don't hear, and it would be quite remarkable if AAG Hector said, well, you shouldn't issue the injunction because we're going to assume that everyone's just going to flout the order between now and November 6th. I think that Your Honor should assume compliance with the law and the naturally attendant harms that would occur from that.
Well,
And
I
you're
think your
not-
argument makes sense if someone could show me these plaintiffs are complying with the law, but nobody said that they have limited their capacity. No one has told me that. I don't see that anywhere in any affidavit that because of this order, they've limited their capacities. They're just saying if we had to, here's what will happen.
Well, Your Honor, what I was
Your Honor.
talking about with Mr. Miller, and I apologize, was he doesn't own a bar. He's trying to plan fundraising events at bars. So he wouldn't be able to say, I'm not enforcing it, but he's saying in an undisputed affidavit that planning his fundraising events is impossible. So that is an independently sufficient reason why this court should not be troubled by this line of inquiry in deciding the merits of this case. But I apologize.
Okay, that's okay. And Mr. Johanningmeyer?
Yes, Your Honor, I want to revisit this because there is no element of obtaining temporary injunctive relief that relies on compliance with the order being challenged for any period of time. The harm we're describing is necessarily prospective because the order only took effect days before we challenged it. Our clients, the whole point of temporary injunctive relief is that they don't have to wait until they're driven out of business by compliance with the order to come to court and stop the unlawful action of the government. Even if no bar in Wisconsin, and I'm saddened by the court's view that people other than lawyers and judges don't comply with the law, because my clients tend to, but if no bar or restaurant or supper club in Wisconsin complied with this order, it would still be an unlawful order. And if they do, under threat of enforcement, which is in the order itself and is actionable under section 227.40 as part of a declaratory judgment proceeding, that is when you come to the court for temporary injunctive relief at the outset. That's why we're here. The status quo is what existed before the order took effect. That's what we're trying to preserve. And whether or not some or many or all of the affected businesses would or have complied during some limited period of time or prospectively doesn't affect that analysis. You see in our affidavits, both from the trade association leader and the individual business operator, what the impact of this order would be if forced to comply. That's the harm we're trying to avoid and why we're trying to preserve the status quo of how things were operating before the order took effect.
Oh, I get your argument. I totally do. If they were to comply, I'm just asking if anyone has complied, but I get no affidavits that they have. So my point is only a practical one. If parties are ignoring the law, how is the status quo changed by me issuing an injunction? That's my only point. It's a legal point, not a political point, not a passion point. It is a legal point because that's what's required when I look at restraining orders. And then I get to the other, or number 4, which is required for temporary injunctive relief, a likelihood of suffering irreparable harm if the injunction does not issue. And I think you briefly touched on that, Mr. Johanningmeyer, indicating there are 20 days that are left here. So I don't know if you want to
one unelected official from doing this repeatedly, other than, of course, the Supreme Court telling her she can't 5 months ago. So the harm will continue to grow. It will be irreparable. Being forced out of business into bankruptcy, whatever other dire financial consequence comes from having certain businesses in particular industries so limited that they can't function is irreparable harm. Some will fail tomorrow, some will fail on day 7, some will fail on day 20. And every one of them will have suffered irreparable harm because the order is unlawful on its face.
All right. Mr. Hector, I have a question then for you. Isn't it true that while this order may have a limited term of 60 days, because one of the state's arguments was that there's no irreparable harm, why couldn't the secretary just issue another order at the end of the 60 days? In essence, trying to avoid temporary injunctions just because of that limit.
Your Honor, let me take that in two parts. The first is that it's the legal burden of the plaintiffs to show irreparable harm. So at the point where they show that, they satisfied that element of the temporary injunction standard. But as I think your questions alluded to, right now their harms are purely speculative. The only irreparable harm that I think was mentioned was the idea that an advocacy group couldn't have in-person fundraisers open to the public while the order is in effect. Well, I'm not sure if that's irreparable, because certainly you could have fundraisers later or in a different manner. But even if it is, that needs to be weighed against the competing public equities in preserving one of the only effective statewide public health measures we have in combating a deadly pathogen that's spiraling out of control. But second, and more importantly, I think that focusing on the time frame is a little bit of a distraction here. The question is whether in the first instance, DHS has the power to take this particular action as an executive action. She does. And to go back to Safer at Home, remember that they upheld the provision in Safer at Home that closed schools. That was subject to the same time frame. So the idea that the time frame here has an effect on the legality of the department's authority just doesn't hold any water. Your Honor, if I may, I'd like to also respond to the point that opposing counsel made about some of the other Safer at Home provisions and the argument that those are basically the same thing that's happening here.
Well, I just want to focus on my
Okay.
questions now. I get that, we could go back and forth for probably hours about this, but I need to focus here on the times. Just give me a moment. I'm reading one of the affidavits here, one of Mr. Miller, one of the interveners. So just give me a moment. I needed to refresh my memory as to the details. Okay. And I have one final question it actually goes to both Mr. Johanningmeier and to Mr. Hector. Mr. Hector, I'll start with you. What do you make of the fact that when the Supreme Court allowed schools to remain open, they did it in a footnote, not even in the body of the decision? What do you make that it's in footnote 21?
Well, I think they actually put it in two footnotes, making it abundantly clear that the school closures were exempt from the decision. But I think the reason that the school closures were exempt really flows from the majority's reasoning. And that is because there was direct authority to close schools. And the discretion involved in how to close schools and whether to close schools to respond to this particular epidemic, that didn't transform that action into executive action. And the same thing is going on here. There is direct authority to forbid public gatherings. The reason that the gathering limitations in Safer at Home didn't fall under that authority is because they extended to both private gatherings and public gatherings. And the capacity limitations extended to private buildings. And the closures of bars and restaurants were just that, closures, not capacity limitations. Here, this is focused squarely on public gatherings. And for that reason, it is directly analogous to the school closures. The reasoning in Palm demands that for executive action to have a lawmaking aspect to it, it needs to interpret the authority that the department has under the law writ large. That's why Safer at Home was problematic under subsections 4 and 6, because the department was making an antecedent determination that it had authority to do certain things, a policy determination that it could confine people to their homes, forbid traveling, and restrict private gatherings. That simply isn't the case here. And as such, fundamental separation of power principles demand that the legislature have no role in something like Emergency Order 3.
Mr. Johanningmeier, tell me what you make of the Supreme Court deciding not to apply the Palm decision to schools, but it's in a footnote.
I'm happy to address that, Your Honor, and I think there are a couple ways to look at that. One, I mentioned earlier, and that is that the statute 252.02 sub 3 does explicitly say the department may close schools. And when Emergency Order 28 did that, it did so without any delineation of type of school, location of school, level of school. Absolutely no discretion or interpretation was used. So it was a potentially fair point that was explicit enough in the statute that they had the authority to do it. But I think, Your Honor, and you've mentioned a couple practical issues in the course of this hearing, and so I'm going to address one of them. The Palm decision was issued on May 13th, with less than a month to go during the school year that would have ended in early June for most Wisconsin schools. And the Supreme Court was certainly aware, as was everybody in Wisconsin, that there was not a single school in this state that was going to reopen in the final 3 or 4 weeks before summer started because of the pandemic. Many of them had gone virtual before the order was even issued. So it's easy to relegate to a footnote because frankly, it didn't matter very much as a practical effect of the decision. That's what was going on at the time. And nothing about carving it out with a couple of footnotes salvages the argument that this statute 252.03 is now empowering the same secretary to do what she's trying to do in Order number 3. If that was accurate, for the third time, the rhetorical, non-rhetorical question, why didn't all the rest of the restrictions survive in Emergency Order 28 for the very same reason?
All right, and Mr. Stateland, do you have any insight as to why the Supreme Court would leave schools open in a footnote rather than in the body of the majority decision?
I mean, far be it for me to, try to analyze the minds of the justices, but I think, most likely there was probably a disagreement within the court about that issue, and they were not able to come to a resolution that allowed for a fulsome explanation. So they cut out that one part of the decision, because obviously you need 4 votes to issue a binding order. I think the important point is that the business closure and capacity restrictions did get 4 votes. And that is, I think, the only thing that is binding upon this court.
Okay. I just need to see if my court reporter needs a break here. No? Okay. As I pointed out to council and to parties, I spent much of my weekend working on this because this is an important issue for many people. I wanted to start out with 2 quotes. The first one is from Justice Hagedorn, and it just is the beginning of his opinion in the Palm case. He says, "We are facing a unique public health crisis like the likes of which few among us have ever seen. And the government response of shutting down businesses, travel, and schools, forbidding private gatherings, and other such measures is a demonstration of government power the likes of which few among us have ever seen. Understandably, our public discourse is full of passionate debate, both over how to handle the public health issues facing our world and over whether this exercise of government power is appropriate for this crisis and for a nation conceived in liberty. And I read that particular quote because I know there are passions on lots of sides here. It's the livelihood of people, it's the lives of people. I appreciate the briefing by all counsel. You are zealous advocates. There was lots of good arguments, so I appreciate that because it assisted me in doing my research this weekend. And then finally, I want to end my introduction with another quote. It comes out of the Helgelin case, paragraph 17. As United States Supreme Court Chief Justice John Roberts has stated, a judge's job is like an umpire's, to call balls and strikes and not to pitch the bat, to make calls according to the rules, not according to the voices of a partisan crowd. And I just happened to find that quote when I was looking at the issue of intervening. It just happened to jump out at me because no matter how I rule, some people are going to be happy, some people are going to be sad or mad. I'm afraid that's just part of recent American culture. But I am the umpire, not the partisan participant in this action. The Palm Court struck down Emergency Order 28 on several grounds. First, that it imposed criminal sanctions which lack specificity, and I'm just paraphrasing these as my summary. It struck it down because of the broad travel and business restrictions were not authorized by statute. And third, that it was not promulgated by rulemaking. So there's a couple of distinctions in this case. First, there are no criminal sanctions to order number 3. There are civil penalties. There are no broad travel and business restrictions. So we're really left with the issue, should this order have gone through the rulemaking process? I can tell everyone involved that I've pored over the Palm decision. And I know there's some people that are watching this because it's the first time I've done this by YouTube. So I know it's more than just the parties here by Zoom. But the Palm decision is 150 pages long in the Wisconsin reports. It has one majority opinion, 28 pages long, 3 concurring opinions, and 3 dissenting opinions. And I point that out because much of what counsel are arguing and then the court asked about is because the decision is complex. There are lots of legal issues which are involved in the Palm decision. When I went through in detail in the Palm decision, it mostly focuses on subsections 4 and 6 of Statute 25203. In fact, one of the dissents noted that on page 591 of the Palm decision, the Wisconsin Reports edition, the dissent, and I'm just trying to remember which dissenter it was, Justice Dallett pointed out, yet it is significant that the majority fails to even mention this subsection, despite Emergency Order 28 explicitly citing 252.02 sub 3 as authority. And she mentions that because in that paragraph, she's talking about 252.02 sub 3. I merely mention that is because the whole argument in this case revolves around 252.03 sub 3 of the statutes, which really was largely ignored in the Palm decision. I not only pored over it, I did a search using Lexis, and 252.03 sub 3 is only mentioned 5 times in the 28-page majority decision. And the last time at paragraph 55, and I quote, "We do not define the precise scope of the DHS authority under section 252.02 sub 3, 4, and 6 because clearly Order 28 went too far." And then as I'm reading through the Palm decision, at the end of the majority decision, in footnote 21, it says this, and I quote, "This decision does not apply to section 4.A period of Emergency Order 28. And 4A of Emergency Order 28 has to do with schools. I thought I had it here, I have a number of pages. But even the footnote doesn't say it's regarding schools, it just gives a section number. And that's what makes, for a trial court, this matter to be difficult from either side. It's not as clear-cut as either side would like to make it. When the Supreme Court does not directly address section 252.03 sub 3, puts in a footnote, which can, the only way I could see it, and that's why I asked counsel, how can you have footnote 21 when you have these other arguments? Because the only way that the Supreme Court could say that the secretary had power to close schools would be under section 252.02 sub 3. They never explained why they exempted schools. In fact, they don't. Except I don't know if I can buy that argument because it should have been explained by the Supreme Court. I looked to the Supreme Court for clarity in following